of the Constitution in relations to the powers of the Deputy Chief Justice. The said ruling, anything else that may have been said that was outside that is direct issue that was before the court, that was not an issue for that ruling. And therefore, dealing with matters that are outside there, and you are be told the ruling has dealt with those matters which it ought not to have dealt with, so it has become res judicata. It cannot become res judicata in our submission. My Lord, with regard to the issue of the friendships, I think this is something that they have been preoccupied with. My Lord, nobody is trying to criminalize friendships, not at all. But my Lord, there are always degrees of friendships. When it is alleged, for example, that a friendships between Kibe and Ndegwa is of such a close proximity that Kibe and Ndegwa ought to disclose that fact to any other person, it would be different, for example, to my friendships with Harvey. Somebody we just meet and do a few cases with. So that, my Lord, the issue at the end of the day is one of degree. To what extent are there interactions between these two individuals? Because, my Lord, and we were saying that you may feel that there are issues. Issues could well be raised. That who was so that, for example, was Judge Mrima from the Kenya Law Reports records, as people would be sending materials to indicate that, the lawyer for Mheshimiwa Kingi during the case with Esposito? Again, the answer would be yes. So this is not a casual friendship. It is a friendship that is over. There have been had client-lawyer relationship, other personal relationships are all there. So that, my Lord, you cannot be able.
Now, how do we respond to that?
Mr. Kibe.
Yes, my Lord.
I had intended to restrain myself,
yes, my Lord,
from interjecting in these applications. But I think the statement you're making is factually incorrect. In the Esposito matter, I appeared as the advocate for IEBC, yes, not Mr. King.
Yes. Thanks for the clarification. My Lord, the issue...
I think if we people can respond on issues of law, it would really help us, rather than going back on issues of facts.
Yes, so that, my Lord, there was a question of forum shopping. Forum shopping, I go with what Mr. Ndegwa has said. If this bench recuses itself, it does not mean that we shall choose any of the judges that may replace this bench. My Lords, on the issue of Mr. Moshemi's submissions, my Lord, Mr. Moshemi's submissions, we start first of all from the premise that Mr. Moshemi did not have a replying affidavit. We did not have a replying affidavit. I tried to object. In order, you said I respond. We want just to draw the court's attention that if you want to take factual deposition, you take somebody else's affidavit that has been deposed to on oath and say, this is not true, you did not sign here, you did not do this, you have not subjected it to any examination or anything. That would be completely to go outside the rules of evidence as we understand them. And therefore, for as much as the issues of Mr. Moshemi is concerned, I urge this court to disregard them. There are two other more important issues that we need to point out.
On issues of law, please.
I thought that was an issue of law. My Lord, I finish with the question that was raised by the one without an affidavit by Michael Moshemi. the issue of Mr. Michael Moshemi, where you are told that for purposes of gauging bias, you should be able to look at the MP for Madeira, who did not, who voted against the deputy president, although he was his father or something in the wedding. My Lord, the direct reference to that would also have to be taken from the bar, the way it was also made from the bar, and the direct reference to that is that the wife of this MP.
My Lord, that's a question of fact.
Yes, it was also the same question of fact.
They didn't reply to points of law, my Lord.
We tried.
We should understand what we mean by matters of fact. Questions of when, who, where, what happened, who did this, who did that. Those are all matters of fact.
My Lord, the only exception, and we said, when we tried to stop, to stand to say that Moshemi is dealing with those issues, you told me, my Lord, you will respond. So I asked that I respond to that issue. That's the last issue. And the response is this, that the wife of that Madeira MP is also on record as having said that I voted against the DP Gachagua because he insulted us and said our wedding will not last. It had nothing to do with the impeachment charges. So that we cannot ignore that is what he said, and it is on public record. So that, my Lord, the long and short of it, so that, my Lord, the long and short of it.
Mr. Kibe,
Yes.
how do I record that?
No, my Lord, the way you recorded, I think I saw a record from the other side.
What you are saying?
Yes.
Do I record it?
Well, I don't know who recorded, but he was allowed to say in open court that even his own MP voted against him. So to be able to demonstrate whatever point he was making. And I'm also saying that from the bar, let it also be made clear that the wife to the she's also an honorable MP, said, I voted because the DP said that that marriage was not going to last. Not on impeachment. So that, my Lord, the long and short of it, because we've had a long evening, is that I beseech this.
I suppose the marriage still subsists, right?
It still subsists. And we also hope, my Lord, that when we are that when we are hard with this petition, the tenure of the DP could proceed. So that, my Lord, the last point that we need to make is that there is somebody, I guess, who is a doctor, and something that Dr. Camino has said, a moment of introspection. This moment of introspection is important. Because for you, my Lord, the issue at the end of the day would remain that an important case is up for determination. Besides the information that is here, if your councils were to show what is it that other things that are coming up in the course of the proceedings, that questions of perception is such a huge issue, my Lord, that if you are to apply the old rule that you are being told to apply, that you have a duty to sit, anybody who does not come with a smoking gun, disregard it and sit nevertheless. My Lord, that would defeat the meaning of let justice be done and be seen to be done. But more importantly, it would also affect my reading of chapter 6, the one that would be said that if there is somebody questioning, like the DP, he has written a complaint, it may be right, it may not be right. It may be upheld, it might not be upheld. But, my Lord, the question is, as we await for that day, should any appeal or anything that results from this case relates to the issue that related to the conduct of the judges, or we deal with the issue of the moment? My Lord, with those submissions, I urge you respectfully, weighty as an enormity of having to argue this application, hold as we have tried to convince you, there are more than reasonable grounds that in existence, that there would be something wrong if one were to say, I will disregard all these issues or technicalities and proceed anyway. I thank you very much, Your Lordships. Evans, oh, sorry. My Lord, Evans, there is an authority, I've been under a lot of pressure that he needed to say something about it. And it's part of me.
What will be, how will others respond to the authority?
No, he's answering the authorities that were used, cited.
My Lord, just note that he has no right of reply.
No, I'm leaving.
We're in the same team.
In the same team.
My good friend, Mr. Wanyama.
Yes, he's actually filed the application.
Thank you to the court. I am fully aware of the long day that it has been, and we don't take it for granted. Thank you very much. I want to respond to the following issues of law. Reference was made to the other side, attaching affidavits to lawyers on this side. Affidavits belong to the deponents, the Statutory Oaths and Declarations Act. Conservatory orders are constitutional orders. They are aimed at protecting the substratum of the case. It cannot be weaponized against this side. Third, the diary case. What should concern this court is the pertinent fact and the act that recusal happened, and what the Supreme Court said about that recusal. That's all what this court is supposed to consider. My good friend, my senior, Mr. Nyamodi, urged the court to ignore certain electronic material that was presented for the lack of a certificate as required by Section 106. I'll urge the court to take cognizance, number one, of the short timelines, the reflex within which advocates were required to make the returns. In any case, we will endeavor to file the certificate. In any case, I want this court to be persuaded by the decision in BBI that formal rigidities should not supervene, especially in a constitutional context, bearing in mind the exigencies and the demand. Because under the Mutunga rules, we can even submit here on non-epistolary basis. Finally, and as I sit to this good court, and we respect each and every of the judges and our colleagues on the other side, 4 things belong to a judge: listen courteously, answer wisely, consider soberly, and decide impartially. Those are the words of Socrates. Thank you, Your Ladyship, Your Lordships.
Are you withdrawing the application?
I think we've come to the end of our proceedings today. We will deliver a ruling tomorrow. Dr. Kamuna, the problem is I don't know whether you are talking as a respondent because you had spoken earlier. Is there something else you want to add?
Under Article 145 and Article 150 of the Constitution. We need to approach this matter very closely, not to be tied by rules of practice, civil procedure, or whatever. We are dealing with a delicate matter. That seems to be the security of the country. And if I may say so, I'm going to say so to honor, with tremendous respect. You need the best peace of mind and the best experienced people to address your issues. It would be wrong to stop you from addressing your issues. This is the first time we are having a much better impeachment. Proceed. Oh, thank you very much. Thank you very much. Thank you very much. My Lord, on my own, And I believe I'm speaking also on behalf of the people of the Syria who respect our justice. I respect our justice. I have been very privileged in my entire life. I've spent it saying, yes, please, Your Honor, yes, please, Your Lordship. I've interacted with the judges, both at my home, eaten with them. They have invited me to their homes and so on. And I have the privilege of working as a judicial officer, as a resident magistrate in the colonial days. And I have the privilege, rare privilege, of being married from judiciary. People serving as a judicial officers are decent people. We may have some isolated cases of some people who are not what we think they should be. But the people in the whole serving the judiciary are decent people. And as a matter of fact, I've said it elsewhere, very loudly too. Kenya is what it is now because of the judiciary. Without the judiciary, you would have something quite different in the country. Judiciary has saved the Kenya, has built the Kenya. We enjoy respect that we enjoy in this country because of, or in the world, because of our judiciary. Our legal authorities, by our judges and so on, are cited everywhere now, including ICJ and so on. They are cited with approval that they are good law and so on. We respect our judiciary. But my lord and my lady, if you look at Article 145, when you're considering Article 145 and Article 150, we have to be extremely careful. We have to be extremely careful. This is a matter touching on the security of the country. And we cannot afford just to stick to certain procedural things or certain evidential things and so on. The court is called upon to look at things very broadly, very, very broadly. What you are saying to your lordship and my lady, very, very respectful, is that so far as I'm concerned, there's nothing wrong with you at all. But there is a significant portion of the Kenyan population who believe that you are not, with respect to the right people to sit and take a case. And I'm saying to you very respectfully, there's nothing wrong. Give us a good opinion, a good judge will want to respect you, and you get out of this case. We do not want protests in the streets. People come to the streets and say, oh, the judges who are biased, the judges who are biased. We do not want that kind of thing. Some of us are too old to leave this country to go to Uganda or to go to Zanzibar and watch and so on, to stay there. We want to stay here and die here. I have gone through an experience which a number of you have not seen at all. When Amin came into power in Uganda, in Kampala, I saw things that were not.
To summarize, please do that.
You always tell me, my God. And also, the professor talked about law. Let me now give him law, which I don't think he knows. My lords and my ladies, I'm asking you to apply a precautionary principle. A precautionary principle is a principle of environmental law. But this principle has now been translated. It is used in matters of security. On our part, we invaded Somalia when Kibaki was in power because of this precautionary principle. And I'm inviting you very respectfully that you apply that principle, a precautionary principle, when considering the matter under the Article 145 and Article 150 under Article 145 and Article 150, having in mind the security of the country, so that we do not have protests in the streets of Nairobi, which will destabilize the country and which will put all of us in an embarrassing position. Your Honor, with respect, I'm asking you again, apply that precautionary principle. And when we ask you to get out of this case, we are applying that precautionary principle, that we do not want certain evil people in the streets of Nairobi shouting, Hatujapata justice.
That is a threat.
Thank you very much.
That is a threat.
That's what?
That is a threat. Don't threaten us.
What's the precautionary principle is not a threat. Yeah. And
My
I
Lord.
sit down, my-
Yes,
I would have
yes.
liked to go on further.
No, please sit down.
And the answer is tremendous respect. My Lord, the answer is tremendous respect. I'm very well read. Thank you.
My Lords, Your Lordship, there's one urgent issue that I would like to draw the attention of this Honorable Court to before the court rises. My Lord, in petition 565, there were conservatory orders granted by your brother, Mr. Justice Chacha Mwita, on the 18th of October. But they expire today at midnight. My Lords, the purpose of the conservatory orders were to preserve the purpose of the conservatory orders were to preserve May I continue, my Lord? The conservatory orders preserve the substratum of the petition and the interlocutory orders application in order for the court to have time to consider
Yes, please.
my Lord,
You are listening.
I was waiting for my Lord Murima, not Mulema, to preserve the substratum, to accord the court time to hear submissions on the weighty issues of law of the Constitution. So my plea is that you extend those orders because they were to expire tonight.
Any response? No. Can we get one response only? Just one response.
My Lord, very briefly. In relation to the question of conservatory orders, the court will remember that we also filed an application under certificate of urgency on the question of conservatory orders. If at all it is now their changed position that the issue as to whether they can be extended or not should be brought before the bench, we are willing, ready, and able to argue it right now.
Well, these are orders that have been granted. They were enforced. There is nothing to argue. We have not come to the applications. In fact, there are another 2 applications for conservatory orders. And I assume that the application by the Attorney General, the Senate, and by the National Assembly for the discharge of the conservatory orders, you'll be here together with these other 2 applications.
No.
I am addressing the court, not the bar.
My lords, if this court is bad for something, it is bad for everything. Until you have ruled on your own suitability to hear the matter. You cannot address any substance.
You are right, Professor Gitu. We meet you tomorrow at 1 p.m. for the ruling.
Thank you. They dug their own hole.
As the sun rises, so do we, as we trust it to rise and set without any worries interrupting your day. StarTime's home solar solution with solar panels, hybrid inverter, and